pessoal, bom dia a todos. Obrigado pela presença hoje nessa manhã fria de São Paulo. Nós estamos aqui reunidos hoje, a Advanbi está desenvolvendo esse webinar junto com o nosso parceiro de tecnologia SISA. A Advanbi é uma empresa voltada para a tecnologia, para soluções de tecnologia da informação. Dentro do nosso portfólio de soluções de tecnologia de informação, nós temos uma divisão que cuida especificamente da LGPD, e dentro da LGPD, nós temos uma visão holística do que seria uma solução LGPD para o mercado. Então, trabalhamos pela ótica de processos operacionais, processos legais, e também pela parte de tecnologia da informação. Hoje a ideia aqui é apresentarmos o nosso parceiro, que tem uma vasta experiência aí no mercado de tecnologia da informação, para a parte de segurança e principalmente com soluções aí de regulamentação ao redor do mundo, tá? O nome desse parceiro é SISA, eles são especializados na parte de cybersecurity. Eles têm presença em mais de 35 países ao redor do mundo, têm especialização em segurança e são muito representativos no mercado. O nosso apresentador hoje vai ser o Kaushik. O Kaushik, ele é um consultor sênior, onde ele tem muita experiência com relação a sistemas da informação que são auditados, tem trabalhado nos principais bancos e operadoras, empresas de TI, BPOs e companhias aéreas e também, e principalmente, os meios de pagamento, né? A CISA, ela vem de uma área de segurança da informação. É também instrutor líder da CPISI da CISA, que é um programa justamente de formação de segurança de pagamentos para as equipes. Então, ele desenvolve e tem esse trabalho também na formação de profissionais para a área de segurança, tá ok? Next one, please. Hoje, como agenda e como vai ser tratado o nosso webinar, ele vai ser tratado com algumas regras, né? A gente vai ter uma duração de 60 minutos do webinar, e no final desse webinar a gente vai estar aberto para perguntas e respostas. Essas perguntas, elas no canto inferior aí da tela de vocês, tem um campo lá de perguntas e respostas, então fiquem à vontade para inserirem as perguntas, vão ser todas via texto, e nós as leremos e transmitiremos para o grupo e as responderemos, né? Os participantes, vocês vão ficar totalmente em mudo para não ter nenhum tipo de interrupção para o instrutor nesse momento. E o webinar, ele também está sendo gravado e vai ser disponibilizado aí no YouTube ou nos meios da CISA, né, na tela da CISA, na página da CISA, para uma eventual consulta ou divulgação, enfim, o que vocês precisarem. Nós, da Advanbi, estamos em São Paulo e ficamos à disposição para darmos continuidade também nos assuntos que vão ser tratados hoje, tá ok? Então, eu estou passando agora a palavra ao Kaushik. Please, Kaushik, go ahead.
Thanks a lot for the introduction, Carlos, and welcome all of you. Very good morning from CISA's end. Myself, Kaushik, and as rightly being said by Mr. Carlos, that both of us, that is Advanbi and CISA, will be helping you guys across in this particular journey with respect to the LGPD. Now, without wasting any further time, let's start with the agenda. So how exactly we have structured the entire agenda is to help organizations, or let's say help you guys understand the criticality of LGPD in today's market, or let's say in today's era, especially when the entire world is talking about privacy here and there. Now, many of you guys might have heard about Facebook. Many of you might have heard about Cambridge and Analytica, according to which many Netflix documentaries, let's say, were made. And that was not just the beginning of the privacy, you can say, regulations. Even before that, the Data Protection Act from the EU was there, or let's say was existing in the market. But even after that, basis upon the current data processing capabilities inside the organizations, many nations came up with many of the data protection directives, starting from the EU. Then, of course, the US came up with a few, and now, absolutely, the Brazil has come up with the LGPD. So, based upon the same line of events, what we have done is that first of all, we'll tell you about the threats, that what exactly are the threats which are there in the market, which led to the introduction of these kinds of privacy regulations. Once we have understood the threat, once we have understood the background behind the introduction of this particular regulation, we'll be talking about that why is it necessary for the organizations to comply with these types of regulations. And once, if you are going ahead with the compliance, if you are going ahead with abiding by the law, by the regulation, by the legality, what all considerations you have to take care of at the very starting, when once you are starting this particular, let's say, implementation inside your organization. And then lastly, section 3, we'll be talking about the Brazil's privacy law and the entire compliance process. So what exactly is the threat scenario today? What exactly is happening? If you'll see across the globe, the cyber attack surface is ever increasing. We have more number of users. So if you'll compare from 2015, there were around 3 billion users, whereas in 2019, we had around 4 billion users. When you're talking about smartphone connections, they have increased drastically. You have more IP connected devices. That's why if you have heard a particular phrase known as IoT, that is the Internet of Things. So majority of, let's say, the devices, majority of the things are now connected with each other via, of course, the IP addresses. There's more network traffic and there's more data as well, which is available in the market. So likewise, if we are comparing it with 2015, then in 2015, we had around 8.8 zettabytes of information, of data, whereas in 2020, we have around 44 zettabytes of data. You can see around 5 folds, or let's say 5x the increase has been in the past 5 years. And basis upon this much abundance of information, abundance of data available in the market, even the cyber intruders, even the cyber hackers are not backing up, are not saying that, okay, we will not do anything about it. They are constantly trying to evade our perimeter defenses. They are constantly trying to intrude into our security controls so as to exfiltrate this particular data. And that is the very reason why we see so many spam messages related to COVID-19 today. We see so many malwares, around 737 malwares have been detected in the past, let's say Q1 of 2020. So many malicious URLs, around, let's say, 48,000 of them. There has been a spike of around 220 times of spam emails from February to March. And the United States, or let's say the entire America region, is around, let's say, a top location, or let's say a target for all the spams and the phishing emails and all the business email compromises and everything. What exactly does that tell us? This particular, let's say, this particular scenario tells us that the cyber attackers are not backing down. They are not slowing down. And that is the very reason why, if you'll see, that around 95% of the breach records came only from 3 industries: the government, retail, and technology. As per the analysis, every 39 seconds there's an attack happening across one or the other organization. out of which 95% of the cybersecurity breaches are due to human error. And as per as per the let's say the cybersecurity reports, around 291 records are stolen or exposed every single second. Majority of the organizations take around 6 months to detect a data breach. Now, we have done a lot of PFI investigations in which we saw that organizations has taken 3 months, 6 months, even 2 years. I believe the maximum time some organization has taken has reached till, let's say, 4 years to 5 years. That after 4 or 5 years, they got to know that yes, they have got breached, which is quite alarming. And the majority of the cyber crimes which are happening in the 21st century is happening from the phishing kind of attacks, and along with the phishing, ransomware is playing a crucial role. And that is the very reason why, if you'll see the turn of events starting from 2011 to 2018, majority of the breaches which have happened because of a phishing email at the back end or a ransomware attack on top of it. Whether we take WannaCry ransomware, whether we take NotPetya as a ransomware, or any other whatsoever, you will see that these guys have been a major threat actor at the end of the day. And as per the study, around 200,000 malware samples are created every day. And 1 in every 100 email actually contains a malware. So with that particular information in mind, with that much threat agents in mind, many of the technical organizations predicted many of the threats for 2020. And majority of them came back by saying that the ransomware will be having a crucial threat attack vector in 2020. And that is the same thing which is happening even today. Business emails, organizations are getting compromised due to the ransomware impacting their organizations. So the ransomware doesn't play, let's say ransomware doesn't come, let's say, solely by itself. It will always be accompanied via a phishing email attack. And that is what again is being happening. That there will be a spam email, there will be a phishing email which will go to, let's say, one of the employees inside the organization, which will have a malware, this is the ransomware. What they will do, they will first of all show that, okay, they are legitimate in nature. Secondly, they will, let's say, make sure that they get downloaded on your system via macros, or let's say via other VB scripts. And then finally, all these types of ransomware will encrypt crucial data inside your system. Now, one thing to note over here is that these types of ransomware do not encrypt the operating system files, because they know that the, let's say, data owner actually has to see the message on their screen that yes, the data, the crucial data has been encrypted. They make sure that the operating system is working, the system is working, and they will only encrypt the all right. I'm sorry, guys, that there is being a trouble in my mute and unmute over here. Okay. So based upon these types of threats, based upon these types of attacks which are happening in the market, okay, what we came across is with that basis upon so many case studies happening across the industry, across the global domain, across so many, you can say, threat profiles and all those things. Top business priority for majority of the organizations is around, let's say, 24%, where they are focusing on the cybersecurity and the data protection. That is an average across all the organizations. And if you'll ask them What exactly do you think are the three biggest legal risks with respect to data? 54% of them are saying that, okay, it's a data breach, because that is the abundance of data breaches which are happening every day. 32% are saying that data privacy is a big issue for them. And the third one is with respect to the big data. Large organizations are saying that, okay, 57%, yes, they'll be impacted with a data breach. 48% are saying that, okay, data privacy will be playing a crucial role, whereas 43% are saying that, okay, data encryption should be done in nature so as to protect the data. So why exactly the organizations, or let's say majority of the organizations today, are talking about these many data breaches, these many security compliances and all those things? It's because they need to agree, or let's say they need to come up with a compliance program. They need to comply with some or the other law, some or the other regulation. How exactly these compliances are driven? All the compliances, whether we take, let's say, GDPR, whether we take LGPD, whether we take a California Privacy Act, whether we take the New York Privacy Act, which is still coming, whether we take the Singapore Privacy Act, whichever one, all of them are risk-based. And that is the very reason why majority of these types of, you can say, data protection directives always tell you, please have an asset categorization first. What do you mean by asset categorization? It means that first of all, identify the critical data, the critical asset inside the organization, and then accordingly start protecting it. Because the maximum risk exposure will be there for that particular asset, which will be having maximum value for you. For example, let's say a social security number. So if a social security number gets exfiltrated, gets breached from the organization, that will be having a major impact on the organization's health, both financially, legally, and of course in the market as well. And that is the very reason, or let's say that is the very instance where GDPR will come into the picture along with the LGPD. So why exactly these compliances are required? These compliances are required because these will set an objective across the organization so that organizations can ensure the PII data and ensure that the particular PII data is secured at the end of the day. All these compliances will be having major regulations, major rules, major policies, major laws. But at the end of the day, all of them will be talking about the protection of data of the end consumer, of the consumers like you and me, when we are purchasing a particular product, or let's say when we are traversing through one or the other sites. And that is the very reason why right now all the organizations, or let's say majority of the global organizations, have come up, or let's say countries have come up with one or the other legislative development. And this is the entire globe where we are talking about each and every country coming up with the Data Protection Act, or let's say Data Protection Bill, in which, if you'll see in America, Canada already has one of them. California is coming up with one, which will be actually enforced in July 2020. Brazil has the LGPD, which will be enforced in August 2020 over here. The New York is coming up with one of them. If you'll see let's say the GDPR, now GDPR is something which is quite prevalent, and let's say the organizations have already implemented, because it was somewhere in 2018, July 2018 when they implemented it. Even the Indian, you can subcontinent also has come up with a data protection bill, the Personal Data Protection Bill 2018, which got presented to 2019. So if you'll see the entire globe from left to right, all the countries right now are focusing upon the privacy of data, are focusing that organizations have to secure the customers' data at the end of the day. And if they are not able to secure, then of course there will be huge fines around them. There will be huge penalties around them. And that is what brings us to LGPD. That is the General Data Protection Law with respect to Brazil. Now, what exactly is this LGPD? In a very simple sense, it's just transparency. That's it, nothing else. The transparency with respect to the data what we as an organization is collecting of the end user, so that the end user knows that what all actions will be done or can be done on my data at the end of the day. And they should have the complete right to stop the processing, stop the storage, or stop the transmission of that particular data, because they are the data owner at the end of the day. And that is where the entire LGPD is coming from. So the LGPD, first of all, will give access to the stored data, means each and every data owner, each and every consumer, each and every end customer will have an access to their stored data. Data portability to another service provider or another, let's say, product or any other service will be strictly monitored, that okay, what can be done, what cannot be done. In the case of protection, or let's say when we have to protect the data, anonymization, blocking, or deletion of unnecessary, excessive, or unlawfully processed data is something which will be given, or let's say they will be given right for. Okay. And lastly, if any of the end consumers think that okay, they do not want that particular organization to process the data anymore, then they will have the right to revoke that particular consent, and the organization, the private industry or even the government industry as well, has to delete, or let's say has to stop processing that particular data element at the end of the day. So whom exactly this particular LGPD applies to? It applies to any person, natural or legal, under public or private law, who processes personal data. Now, this can be a private organization, this can be a governmental organization, this can be a public organization whatsoever. So LGPD is actually applicable to each and every domain. It's not specific to private ones. And where exactly it applies to? It applies to personal data. So what exactly is personal data? Something like, let's say, registration data like name, social security number, email, telephone address, GPS data, electronic information like an IP address, and so forth. Majority of the general data protection directives across the globe do not define these sensitive personal data elements. And that is the very reason it becomes really, really important for organizations to protect each and every data element inside their organization which they are collecting from the end consumer. Because at the end of the day, a particular user might be identified by combining 2 or 3 different elements, or let's say 2 or 3 different data elements. For example, if I get a name of an individual inside my organization, if I'm storing that particular name, now with the name of an individual, I might not be able to uniquely identify an individual, because there might be 2 people with the same name or 10 people with the same name. However, if I combine this particular information with the address, with the telephone number, with the contact number, with let's say an age, with the date of birth, with the location, with the place of origin, and many other things, in that particular scenario, the risk exposure increases, and I will be able to uniquely identify that particular individual. And that is the very reason why it becomes crucial for organization to find out the data inside their organizations, that what exactly they are storing, processing, or transmitting at the end of the day. So personal data or sensitive personal data, like let's say an ethnic or racial origin, political opinion, union membership, biometric data, health or sex life data, stricter rules and greater penalties for anything possible. So all the types of data elements basically have to be protected at the end of the day. That is what GDPR talks about. And if you compare this GDPR with majority of the global directives which are there inside the market right now, you will see that it is, let's say, somewhat at par or even greater as compared to the other compliances, or let's say other regulations what are there inside the market. So if you'll see, as per the GDPR, it of course got formulated, or let's say the effective date was around May 25, 2018. The California Privacy Act, the Consumer Privacy Act, came in January 1, 2020, whereas Brazilian, let's say, data protection law will be coming into force from August 15, 2020. EU members, they are saying that, okay, DPAs are necessary over there. In the case of the California Privacy Act, they are saying that the California Attorney General has to be reported for all these things. And in Brazil, they are saying that the Brazil Data Protection Authority has to be reported if in the case of any of the mishappenings or anything which is being done inside the organization. It will see the personal data, the applies to, and the other things. More or less, majority of the things remains the same. However, what we need to ensure is, or let's say what we need to take care of, are the penalties. So in the case of penalties, in the case of GDPR, they are saying 20 million euro or 4% of the global turnover. In the case of, let's say, the California Consumer Privacy Act, they are saying $100 per incident, and $750 per consumer per incident, or actual damages up to 7,500 for each intentional violation. Now they are going per consumer basis. So if, let's say, around 100,000 you can say data, or let's say 100,000 information is compromised at the end, then it will be just multiplied with 100,000 in the case of California Privacy Act. So that is which is quite alarming. Whereas when we come to LGPD over here, LGPD is saying that 2% of gross revenue in Brazil, to max of 50 million Brazilian dollars, and also outlines the daily fines as well. So they have changed over here. They have come up with a cap as well of $50 million over here, and they are saying that, okay, or 2% of the gross revenue, or $50 billion. Now, whenever the data protection, whenever the privacy comes under picture, majority of the let's say organizations or majority of the industries always refer back to the GDPR. If you refer back to the GDPR and compare this service, that, okay, how exactly is LGPD different, we'll talk about that the anonymization of data. Anonymization means that when two data, even if it is stored together, cannot be related to one another. Now, GDPR says that, okay, it can be considered out of scope, whereas LGPD says that considering the personal when used for behavior profiling, it means that it will be considered personal if you are using it for behavior profiling. And what do we mean by behavior profiling? It means, let's say, for marketing purposes, where you are showing, let's say, specific ads to specific people. Then in that particular case, even anonymized data will be considered personal in nature as per LGPD. Legal basis as per which, let's say, organizations can, let's say, go ahead and, let's say, store particular thing, or let's say process data, the personal data processing. Legal basis, GDPR is giving you 6, whereas LGPD has gone forth and giving you 10 over there. Okay, which includes the research rights in legal proceedings, health protection, credit protection as well. In the case of consent, which is a major factor over here, GDPR says it should be explicit, LGPD says it should be specific in nature at all the times. The specific means that if the organization, if that particular organization is saying that, okay, they will be using my data for digital marketing purposes, then they have to use only for digital marketing purposes and nothing else. That particular language cannot be vague in nature at all. Legitimate interest requires a balancing test, whereas requires promotion of control of activities, and something which has raised the bar in the case of LGPD is subject access request. That is, if I am the owner of the data, if I am the end consumer, then I can ask any other organization whosoever is processing my data, and they have to respond or to my request within 15 days. That is what LGPD is defining. Whereas in the case of GDPR, it was 30 days. So LGPD has reduced that particular timing so that the end consumers have more access to their data and can get a timely, you can say, access response as well around it. Based upon the breach, GDPR says around 672 hours is the time period in which you have to contact basically the DPAs. Whereas in the case of LGPD, they are saying a reasonable time. Now, this might be amended as well at a later point in time. But as of now, they are only saying that, okay, it's a reasonable time, which has to be taken care of over there. So when we have seen that, okay, what exactly is LGPD, when we have compared it with the major, you can say, regulations across the globe, now it's time to actually implement this LGPD across the organization. How exactly it has to be implemented is that, first of all, organizations have to have a strategy around it, have to have a privacy strategy around that particular thing. Now, privacy strategy will be, let's say, a bit, or let's say, somewhat vague in nature if I haven't actually found out that what exact data do I have in hand. And that is the very reason why processing the inventory as well will be having a crucial role. So once I have, let's say, a strategy defined at a very high level, and I have some data along with me, along, let's say, in my hand, and I know that, okay, I have to protect this particular data, what I'll be doing is that I'll be going ahead with a few of the assessments so that I can identify and make sure that the data at the end is protected, whether it's stored, processed, or transmitted. I will be doing a privacy impact evaluation. Now, what exactly is the privacy impact? It's similar to the risk assessment. But over here, the major focus is about the assets and the exposure of the assets. They have to come with a privacy by design. A training and awareness is absolutely necessary. Different data management practices have to be followed, and organizational responsibility have to be adhered, or let's say have to be maintained throughout the organization. That is how organizations will be able to implement, let's say, the LGPD at the end of the day. And before even starting with any of these things, as I said, that, okay, strategy will play a crucial role. And that is the very reason why the privacy policy will play a crucial role over here. What exactly is a privacy policy? It's a legal agreement that tells any of the website visitors, or let's say any of the, you can say, end consumers, that whatever information you are collecting it for a particular purpose, and let's say you will not be using it for any other purposes whatsoever. Okay, you have to make these particular, let's say, these types of policies much more user friendly, so that people don't have any challenges in actually reading and understanding these privacy policies. And why exactly organizations need a particular privacy policy? So that organizations will also know that, first of all, they are processing, or let's say they are collecting the personal data on behalf of the end consumer, and they can have a grasp, a control on that particular information while storage, processing, and or transmission. And what all things have to be there inside that particular privacy policy? It should have the business details. It should have what information you are collecting. So when we talk about what information, it means, let's say, the name, the gender, uh, any of the ages over there, the date of birth. If you are collecting the IP addresses, then even the IP addresses will be there, and all the effective date, the contact information. And it should also strictly communicate that how exactly end consumers can come back to your organization and can ask several questions around that. That is, if, let's say, tomorrow that particular end consumer comes and say that, okay, now I do not want you to process my data any longer, then there should be a clear guideline from your organization that, okay, there's a portal, or let's say there's a particular website over there, you can come, let's say you can make a request, and within 15 days you will get a response from our end with respect to that particular data subject access. which is quite necessary in nature. So what all data elements are considered to be private, or let's say what all data elements are considered to be PII data? Now, this is something which is vague in nature. However, majority of the organizations will be taking one or the other of these data elements, starting with the date of birth, to religion, to race, to address, to image, to fingerprint, to login IP addresses, to weight, place of birth, and hence so forth. Now, any of these data elements might be PII in nature, or these data elements might be, let's say, can be combined with other data elements so as to uniquely identify a particular individual. And that is the very reason why data classification plays a major role when organizations are tending to implement this particular kind of data protection or say data privacy regulations. So this particular data privacy regulation, first of all, requires organizations for finding out the data elements. Now, before even finding out the data elements, what organizations have to do, they have to have an asset classification as well, or let's say the data classification as well. They should know that, okay, which all data elements will be public in nature, which all can be used internal only, that is internal to the organization, which all data elements will be confidential in nature, that is, if they are compromised, they will negatively impact the operations of an organization, and which data elements are restricted in nature. That is, they're highly sensitive, and if they are compromised, then they will have a huge impact on the financial and the legality of an organization. Now, the restricted can vary from, let's say, an IP address to credit card information to social security numbers to EPHI data, that is the public health information. And why exactly is restricted? Because using this, I can uniquely identify a particular individual. The confidential information can be, let's say, a contract with vendors or employee reviews, etc. The internal only can be, let's say, a sales playbook, organizational charters. And finally, the public can be the marketing materials and something which are available over your website. Now, once I have defined the asset classification, now it's very important for us to, let's say, have categories inside the assets as well. Now, what exactly the categories will do? It will establish the type of data that is spread across the infrastructure, and how exactly you, or let's say your organization, will be able to collect the data, or let's say do a particular asset categorization. Is first of all, you have to ask yourself, or let's say your organization, that what type of customer data is being collected. You might be collecting an IP address, you might be collecting a name, you can put the phone number or something like that. Post which you have to understand that what proprietary data is being created about consumers. And lastly, what is confidentiality among collected and created data? That is, I might be collecting n number of elements whenever a request is coming on my website. But what exactly is the confidentiality element from it? So what exactly mean by confidentiality? It means that the unauthorized access on that particular data should be restricted as much as possible. So once I have the asset categorization, once I have the, let's say, the asset structuring being completed, the next thing which falls off is finding out the assets inside the organization. That is the data discovery. Now, data discovery is one of the most important steps whenever organizations are tending to follow any of the compliances whatsoever. Why am I saying this? It's because organizations cannot go ahead and protect each and every data element which is, let's say, stored inside their organization. They have to first of all find out that particular data and then accordingly protect the most critical data inside their organization. And how exactly we can do it? We can do it via, let's say, by many of the automated tools which are available in the market, so that once we have identified the particular data element, I can put them into the categorization of, let's say, restricted or super restricted, or let's say super sensitive or public or confidential, something like that, and accordingly have protection around it. Likewise, for example, LGPD data protection will be applicable on the personal information, the location history, and the contact information. And how exactly we'll be able to find it out? We'll be able to find it out based upon the data, or less the data discovery inside the organization. First of all, I need to identify, because what happens is that whatever request is coming to your application, whatever request is coming to your application server, um, organizations tend to store majority of the information in the application logs. Why? Because that was basically how the applications were built out of when they were built. Because at that time there were no data privacy directive. At that time there were no confidentiality agreements as such. So they just started storing each and everything. And that is the very reason why data discovery will play a crucial role. So that at the end of the day, if that particular data is not required, then you can go ahead and delete that particular data element. And if you require to store that particular data element, then you can either encrypt the data element or mask it and make it unreadable. Or something which, let's say, the LGPD and GDPR prescribes, anonymization of the data can also be done, which will make sure that that particular information is secured at the end of the day. Now, based upon the data discovery, what exactly the next step should be? This particular data discovery tool or this particular data discovery step, whatever you might be having, okay, should comply with majority of the data security laws and requirements. Why? Because at the end of the day, you or your organization might have to comply with different local law of land. Like GDPR can be there, PCI DSS can be there with respect to payment data security, OIAP is there, LGPD is there, and hence so forth. Because each and every organization always have a global footprint. Now, in the case of global footprint, it is very important that even the tools, the technologies which they are subscribing to supports the entire, you can say, the plethora of the legal regulations. And that is the very reason why most of the organizations or majority of the organizations are implementing or updating their internal privacy policies. Around 47% of them basically, okay, or let's say 47% of them are basically focusing on the internal privacy policies across their organization. Now, what exactly they are thinking of is that if the internal privacy policies have been constructed in such a fashion that, let's say, the entire PII data is protected at the end of the day, it will give much more granularity, it will give much more control over the data so that it can be protected at the end of the day. And basis upon the same, this LGPD will be a boon to the society, because it will bring so much transparency across the users, across the customers. It will give, let's say, so much risk and failure management support, because at that time we'll have, let's say, we'll have an idea that the particular data which we are storing, the particular data which we are processing, how much risk exposure is there with respect to same. It will define clear-cut responsibilities between different owners, or let's say between different players inside the market. If you'll see the LGPD, basically the LGPD directive, it's also defining 4 types of basically actors. So when we say actors, it means that, okay, these 4 types of people or these 4 types of players will play a crucial role. First is the owner, which is the consumer, the end consumer. The second one is the controller, who is directly, let's say, capturing the data. The third one is the processor. The processor is, of course, the service provider at the back end. Means, let's say a particular website is capturing that particular information, that there is a service provider at the back end who is processing that particular data. So then there will be the processor, and lastly there will be the DPO, that's the data protection officer, which will be there for the data controller and which might be there for the data processor. Why am I saying that, okay, DPO might be there? It's because based upon the GDPR said that, okay, if your organization has too many transactions, or let's say has too much data processing, then in that particular case a DPO can be appointed. Whereas in the case of LGPD, they haven't strictly defined this particular policy. They are saying that, okay, organizations should have a DPO in nature. So in that particular case, majority of the organizations will be ending up with a DPO, or let's say with the role of DPO amongst the organization. It will also talk about extraterritorial coverage as well. What is this? It's because if the organization is based out of Brazil or not, that doesn't matter. If they are processing the data of the end consumers or the residents of Brazil, then they'll be coming under scope. International transfer will also be, you can say, controlled via this, and the centralized supervisor will also play a major role when it is coming to picture. At the end of the day. So with that particular note, we say that don't let your trash become someone else's treasure, and feed your shredder very often. That is, at the end of the day, please make sure that if the data is not required, please shred it off. Please dispose it. Please do not keep it. Otherwise, if you are keeping that particular data element, then you have to abide by so many laws, and you also have to make sure that if anything happens to it, then your organization will be responsible for the same. So a few tips from our end to secure personal data is, first of all, have let's say a data analysis, or let's say a data evaluation, or let's say a data discovery tool, so that first of all you understand that which all data elements are you capturing, which all data elements you are storing at the end of the day. Once you have evaluated, or let's say once you have categorized these different types of data elements, it's very important you should have a privacy by design. Privacy should not be, let's say, a one-day job or something which is just kept in a policy and, let's say, kept aside. No, it should be a part of your BAU. It should be a part of your business as usual. And then only the data protection can be improved. Data privacy should be focused at all the times. Information governance will play a major role when you are implementing the PII, or the LGPD across the organization. And you should have a strong and effective privacy communication plan at the end of the day. So this particular data protection should be there across the organization, and that is something which we have tried and you can say tried to formulate and kept over here. And that is something which is for your reference purposes, which you can go back and read. That this particular, the LGPD, when you are going ahead and implementing it, you have to make sure that the data subject rights, the profiling and the profile-based decision making, the consents, data processors, data mapping, and all of these different aspects are taken care of, or let's say are very important to be maintained at the end of the day. Now, with that kept into mind, it's very important that today the organizations cannot say that, okay, they are not going to store the customer data, or they will store the customer data in silos. No, that might not be the case, because they might have to address data privacy regulations from each and every country, from each and every domain at the end of the day. So it's very important that they perform the categorization of assets, the identification of assets, and accordingly start protecting those assets across the organizations. And that is where we will be able to make sure that the breaches, let's say the threats and attacks, whatever is happening across the market, do not impact our organization. And we won't be the next Facebook, or let's say we won't be the next Cambridge Analytica, or we won't be the next British Airways or any other organizations who have got breached and have imposed so much fines on top of that. So with that kept under mind, we'll go for the Q&A section. If you have any questions, then please type it in the questions box, which will be there on your screen, and we'll be able to answer them.
Thank you, Kaushik. Pessoal, estamos abertos agora a perguntas e respostas. Vocês devem ter aí no canto direito, aí no final, um botãozinho de perguntas e respostas. Fiquem à vontade para fazer as perguntas. Tem uma primeira pergunta aqui, que eu li que a data de início de validade da LGPD foi alterada devido à atual crise do Covid. Qual a nova data? Já há uma definição? Kaushik, it's regarding the starting the law in Brazil. I can answer this question. Bom, pessoal, com relação à pergunta, a gente ainda não tem uma definição final da data de início da LGPD. A decisão mais recente que teve foi agora dia 19 de maio, essa foi uma definição que chegou, onde a lei, a LGPD, ela entraria em vigor a partir de agosto desse ano, voltaria ao texto da primeira postergação, né? Agosto desse ano já seria a primeira postergação que foi feito lá atrás, mas as sanções elas só entrariam em vigor a partir de maio. Tá? Então, esse é o último texto, é o que está sendo tramitado, depende agora da revisão da Presidência da República, se vai seguir adiante com essa definição ou se vai ter mais alguma mudança. Tá? Para vocês terem ideia, na sexta-feira retrasada teve uma mudança e nessa sexta-feira passada também teve outra mudança. Então, tiveram duas mudanças seguidas aí com prazo de 7 dias. Perguntando se o webinar pode ser revisto mais tarde. Sim, o webinar ele vai estar gravado e vai estar disponível tanto no site da SISA quanto no YouTube, assim como no nosso site aqui da Advanvisa, a gente vai compartilhar com vocês também. O que mais nós temos aqui? Tem uma pergunta aqui, perguntando a respeito do processo de implementação para a LGPD, quanto tempo leva. Kaushik, regarding the LGPD implementation process, the question is how long it takes.
Okay, so LGPD is entirely dependent upon the organization's exposure to PII data. So if let's say that particular organization is keeping data backup across 10 to 15 locations across, then it might take 4 months to 6 months to 1 year as well to implement it. Whereas if they have already centralized the data into one particular center, or let's say into one particular data center, one particular AWS scope, then it might be done in the next 3 to 4 months as well. So it is entirely dependent upon the data size.
Ok, thank you. Nós temos aqui uma outra pergunta com respeito, dado que ainda não temos detalhes da atualização da Autoridade Nacional de Dados aqui no Brasil, gostaria de saber um pouco mais de como costuma ser a atuação do órgão governamental de regulamentação junto às organizações em outros locais do mundo. Costumam atuar sobre demanda, quando há uma reclamação, por exemplo, ou é uma ação dinâmica, mais estruturada? Com as plataformas que temos hoje de fiscalização. Kaushik, it's a question regarding about your experience in terms of regulations around the world, how it works. In Brazil, in particular, it's not so fully implemented, our ANPD. So the question is how it works around the world, if it is more reactive, I mean, in terms of some people that make some warn about the leakage, information leakage, or it's more structured the dynamic from the government. It's a kind of auditing, constant auditing in the market, how it works.
Sure, Carlos. So basically, I'll explain this with a scenario. So likewise, when Facebook got breached, when British Airways got breached, many different organizations got breached in the EU. Before that particular time period, majority of the organizations were thinking that even if in the case of a breach, we will not be held responsible, or we won't have a, let's say, a fine, or let's say we won't be imposed a fine. Now, after these particular breaches happened and the GDPR imposed fine, a huge fine of millions of euros, millions of dollars, and everything on these particular agencies. After that, organizations have started implementing privacy from the very inception of their business practices. Now, that is with respect to GDPR. Now, when the California Privacy Act came, at that particular point in time, organizations made sure that their business is ready at the end of the day. And they didn't think twice before even implementing the privacy practice. So to answer the question in one simple line, earlier, or let's say 2 years back, it was reactive in nature. Now organizations are proactive in implementing the LGPD, or let's say in implementing the privacy directives.
Ok, good, thank you. Tenho mais uma pergunta aqui, ela faz um link com a pergunta anterior, como a lei será verificada nas empresas, está dentro do que o Kaushik acabou de comentar, que é o que ele viu ao redor do mundo. Em termos do Brasil, isso daí ainda não está definido, e se as empresas terão que enviar isso para algum órgão, né? Aqui existe a figura do DPO, ou do encarregado de dados, ele é a ponte entre a NPD, que é a Autoridade Nacional de Dados, junto com as empresas, tá? Então, todos os relatórios de conformidade, tudo isso daí vai ser feito através do DPO, ou do encarregado de dados, que seria a terminologia nacional, junto com a NPD. Tem mais uma última pergunta aqui que eu vou fazer. No caso de empresas que possuem canais de distribuição independentes, como concessionárias, franqueados, etc., as informações são coletadas pelos canais, mas são geridos pelo fabricante ou dono da marca. Quem será o responsável por implementar a LGPD ou responderá pelos dados sensíveis? Well, Kaushik, a question here is regarding the implementation. If you have the implementation in a company, LGPD in a company, but there's all the chain of the third parties involved, we will be in charge of to manage the situation, because I believe that all the companies will be responsible to be compliant with the LGPD. That's the way. Am I right?
Right, Carlos. So how exactly it works is that let's say there are data processors and then there are data controllers. Now, whosoever is interacting with the end consumer directly, like let's take the case of Facebook again. Facebook will be capturing the data from the end consumer directly. So Facebook will be the data controller over here, and the data owner will of course be the end consumer. Now let's say at their back end, if they are sending these logs to some other service provider, then that particular service provider will be the data processor. Now, as per the, let's say the LGPD or the GDPR, any other regulations, the data processor and the data controller both have to be LGPD compliant, or both have to be GDPR compliant at the end of the day. That's how it's driven.
Ok, guys. Pessoal, muito obrigado. Nosso tempo já deu. Obrigado pela participação, pelas perguntas. A Advanbis e a SISA agradecem muito. Thank you very much, Kaushik, for your presentation. It was very good, and I believe that will be very useful for us here in Brazil. E ficamos à disposição até os próximos contatos, tá? Advanbis e SISA agradecem. Muito obrigado.